Okay, well, good afternoon and welcome to our Live at Lunch. Today we're doing Becoming Competent on Competency, and our faculty, we have three distinguished guests today. We have Travis Fink with Indigent Defense joining us, Aaron Burse with Association of Counties, and Dr. Rosalie Etherington with the State Hospital, and they're going to guide you through a number of things today regarding changes in the statutes around competency. And I believe they also want to hear from you as well if there's some issues or concerns or things that aren't quite clear. So feel free to unmute yourself or turn your cameras on and participate however you see best, or in the chat, and I will monitor the chat. So Travis, go ahead, I'll turn it over to you.
Thank you, Leanne, and thank you everyone for being here. I'll go ahead and share my screen. Can everyone see my screen okay?
Yes.
Okay, so we just wanted to, I reached out to Leanne. The Supreme Court has had a work group going for some period of time. And from that work group, there was some other groups that got together and really started looking at some competency. And we've had an opportunity to sit down with prosecutors, defense lawyers, and also the doctors from the state hospital. And really what was born of that was House Bill 1181 from last session, which really rewrote 12.104, which is the Century Code provision relating to competency, and really brought it into today's standards. We did have technical assistance from the National Center on State Courts, as well as to some best practices and what some other states were doing as far as the statute. So what we wanted to do, since the statute's been in place now for about 6-7 months, is take some time and go through and really walk through the statute, what some of the changes were, and then also provide opportunity for you as judges to provide feedback as to maybe what is working, what isn't working, what you might be seeing, and so we can make tweaks if we need to the statute, or make recommendations for some legislative changes, but then also just maybe even procedural changes that we're implementing in our respective areas, either on defense, prosecution, or on the hospital side of things. So I'll just get going here, and at any time feel free to stop us. So one of the biggest things we did in the rewrite of 12.104 was added specific definitions and clarify some of the unique terms that are used in competency, really trying to make sure that it was clear that competency is separate from criminal responsibility. As what we found when we first started this work group several years ago is there was a lot of blending of the lines between competency and criminal responsibility. So again, today we'll focus simply on competency, or that fitness to proceed part, which is found in 12.104. The new law also sets definitive timetables for when evaluations must be completed and when the reports must be written. And also one of the big changes, which was changing the language from temporary commitment to the state hospital for purposes of evaluation to temporary detention, as committing someone to a state hospital carries certain connotations and requirements under other parts of the Century Code. And then also, really for the first time ever, there's a clear method of competency restoration, myself included. Several times in my days of practice, we would have individuals who were found to lack fitness to proceed, and they would be referred for competency restoration, wherein the old statute really had no reference to the procedures to restore competency. So we really relied on that criminal responsibility chapter that does have the restoration to provide guidance. Whether right or wrong, that's what we did in the past, but now we have it specifically laid out in chapters. So we'll go through each section, and feel free to stop if there's any questions, and Doc and Aaron, feel free to jump in at any time. The first one really is the biggest definitions, obviously, is that fitness to proceed, which is essentially the Dusky standard, or the modified Dusky standard, making sure that there's a reasonable degree of rational understanding, as well as that factual understanding of the proceedings by the individual. So that ability to have that meaningful communication with counsel and have that understanding of the proceedings. Also, we have in here least restrictive appropriate settings. So again, what we've done, we've provided each section of the code here, and Leanne will mail this out to you all as well. But then we've also highlighted the terms that we think, or where we think it's important for the court to know. So we also have therapeutically appropriate treatment, and provide the definitions there as well. So I don't know why this is all messed up, and I apologize that it is. Starting with 12.104.1, there is the presumption that a defendant is fit to stand trial. So that obviously carries the weight of a presumption. And so any person who appears in front of anyone at any given time is presumed to be fit. Naturally, one of the things that carried over from the old laws, the case law that says if an individual lacks fitness, they cannot be tried, convicted, or sentenced. Really what we wanted to focus on and what we focused our talks on when we've talked to, and we presented now to defense lawyers, we presented at the State's Attorney's Convention, is really focusing on the fact that competency is that justiciability issue. It's really that hurdle that we all have to get over before the case can really proceed. So making sure that while that presumption exists, if there's questions as to competency, we need to be taking a look at that case. And I think based upon the numbers we've seen at the state hospital, I think we're getting a lot better at recognizing when there is competency issues. And Doc, maybe this might be a good time to just segue into maybe some of the increase in the numbers that you've seen.
So we have over the last probably 18 months to 2 years seen about a 400% increase. So there's been about a 500% increase just in court-ordered evaluations generally. So that would be for competency, criminal responsibility, and we've seen then a coordinating rise then in those that are not fit to proceed and coming for care. So previously, and I would say of a 20-year average, we would have 1 to 2 individuals per quarter that required treatment for restoration of competency. And now at any given time on our campus, we have somewhere between 10 to 20. So as of today, there are 16, and there is 1 more coming in. So it's a dramatic increase.
And so the discussion has been in our work groups has been, are we just more aware of it? Is there more mental health issues out there? Were these people that maybe were previously, entering into plea agreements without, really having that factual and rational understanding of what was going on? So while that does appear to be a challenge in simply the numbers, to someone like myself, I think that's exciting to see that we're getting better at recognizing those justiciability issues.
And Travis, sorry, if I may,
Yep.
it's I think important also for the judges to understand that I think from a national perspective, there has been an increase. So there's been an increase of not just recognition, but an increase of individuals that have been found not fit to proceed. And there is at least some anecdotal information that would suggest the COVID pandemic has maybe played some factor in this, but not really the complete answer for why there's been an increase.
Yeah, and there's all kinds of research out there as to what potential we might be seeing from long haul COVID and what sort of mental health effects that may be having and what that's going to look like in the future as well. Additional thing that we added that wasn't in the old statute is a requirement that these filings be kept confidential and listing specifically who can receive the reports and who doesn't get the reports. So the report that comes back from the state hospital for competency is confidential. Because it is competency, it does go to the court, it goes to the defense attorney, and it goes to the prosecutor. The important thing is really that confidential piece. I think they were being held confidentially by policy, if I remember correctly, of the court, but this really made it statutory to make sure that we are providing those protections to individuals who are going through this process. Excuse me. 12.10406, again, the big shift there was changing from the temporary commitment to temporary detention for purposes of examination. And it's important too that the evaluation be done or the examination be done in the least restrictive setting. So what we did is we went through and really tried to lay out from most restrictive to the least restrictive type setting. So obviously the most restrictive type setting is the state hospital. Typically that becomes the default for most practitioners when they're requesting these evaluations, is they request them at the state hospital. I think it's important, and what we've pushed some of the practitioners I guess a tale of caution to the judges would be to consider those least restrictive alternatives. So whether that be a human service center, that would be able to provide at least the facility for it, and then they can do an outpatient examination through reliable electronic means, whatever it would be, to at least consider those facilities. We did build into this new statute the fact that there should be some outreach to the Human Service Center prior to recommending that, to make sure that they do have the capacity to hold them. Another thing that comes
Travis, can I just stop you there? Judge Bailey has a text that says, how is a trial court to make a determination finding of incompetency in reliance on a confidential report? Can you just explain a little bit more on that particular process for Judge Bailey, and why that was so important to the treatment for professionals?
Yeah, so the report itself is confidential. Obviously, the proceedings are judged differently. There's obviously discussion about the report, but the reason the report is to be kept confidential is not only did we have prosecutors and defense lawyers on this, we also had psychiatrists and forensic psychologists and psychiatrists on board as well. And they indicated that most of the materials which they use to conduct these evaluations, they actually sign, I don't know if it'd be user agreements or stipulations, that they will hold those materials to be confidential and can only be released in certain situations. So really what we had in the past, by not having a statute that said they were confidential, we were placing a lot of our forensic evaluators who are doing this work in this kind of Hobson's choice of, do we provide the information, and how in depth can we provide the information to really allow the court to make that better determination versus, having that report be kept confidential. So that's why we went to confidential. The proceedings are still open. Obviously, the parties would have that report. It's not anticipated. I've never been in a situation where the report was read out loud. There might be certain parts of it, but obviously there's extremely confidential stuff in those reports, such as substance abuse history, a lot of those things that really have secondary concerns of dissemination. So did that answer your question?
Well, I'll let her text back again or ask the question directly. This was, judges, this was a point of considerable discussion and debate, and quite frankly, the prosecutors were a little uncomfortable with this, but it was really being driven by a lot of the treatment professionals that felt that's critically important. I've just got a couple other chat boxes. I'm just going to read them. Let's see, Judge Hager, are we not violating the confidentiality if we have a hearing when the defendant contests the state hospital report, unless we close the court proceedings to the public? Could you address whether those need to be closed or not? And I know there is a number of court cases that make me super uncomfortable with this also, but go ahead, Travis.
Because of the number of court cases, I don't know that I would be the expert that would speak as to whether or not those can be closed. Again, I think similar to the nature of a pre-sentence investigation report is also confidential, but oftentimes those are discussed in sentencing hearings as well. So the report itself is confidential, but I don't think the hearings need to be closed. I think as long as the court has read it, the prosecutor has read it, and the defense attorney have read it, you can have a learned discussion in court and make a decision without having those types of questions. Typically, when there's been contested competency hearings and there's examination provided, it usually does not go into the confidential nature of the report, just rather how they made the findings they did. So I don't know that that would be a problem, but I also don't know that that's really, it's not covered in the statute. That would be up for the court to make a determination based on the court's rules.
And I do think that's probably something that we need to take a harder look at if we are going to tweak this statute. It's readily apparent to me that the North Dakota Supreme Court has really got the thumb on the finger for not closing hearings. State versus Rogers is pretty clear about that, unless there's extraordinary factors. So my impression is this is all public hearing, but we'll have to tread lightly on the confidentiality of the report.
This is Susan Bailey. I'm the one who raised the question. It's a little late if it's already statute, but if I am required to make factual findings and the basis of the factual, I don't know how I can rely on things I learn from the report without violating the must be kept confidential, without saying what those things that I am relying upon are. And I think telling us in a CJE to wink, wink, nod, nod at, oh, well, you can read it and then talk around it in open court, that is no solution and no guidance to the district courts. It's a landmine.
And it's not meant to be a wink, wink, nod, nod. What I'm saying is what typically happens is we already have this in place. This isn't a new thing. These reports were kept confidential by court rule, if I recall correctly, prior to this. So the only thing we're doing here, and it's not a wink, wink, nod, nod, it's a reference no different than sentencing when you reference the pre-sentence investigation report. The pre-sentence investigation reports are confidential documents. Those are not allowed to be disclosed. Doesn't mean they can't be referenced. So the reality is if the parties have read the evaluation, typically what the orders say is based upon the report filed by the doctor or based upon the opinion of Dr. So-and-so, I'm ordering that, you know, that proceedings be suspended, and that, you know, whether there's a finding that they are restorable or not restorable, determining whether or not someone would be sent for restoration of competency. So I guess I don't see.
I'd be surprised if the Supreme Court would accept a finding like that without further factual findings.
Well, I think that's the way.
Same, for example, failure to make specific factual findings when doing an annual review in an SDI case, sexually dangerous individual case. I myself have been reversed and remanded for failure to set out specific factual findings, independent, specific factual findings. Cannot simply say, well, the report made an ultimate conclusion X, therefore the court makes ultimate conclusion X. And that has been found to be insufficient and reversed.
But I think that's a completely different type of finding, because that's not a justiciability finding. This is almost a hurdle. It's not, I mean, it's different than an SDI type thing where you're imposing some sort of whatever it would be on, and I'm not an expert on the SDI side, but on this side of things, it's really that justiciability issue that is the hurdle you're getting past. So I guess I don't know that I've ever seen, I mean, there's not many competency cases really that move past this point. And the only time there really requires a finding, typically what happens in these cases is when the report comes back from the state hospital, if it finds that a person is not fit to proceed, that they would then, there's usually a stipulation, especially if the person is deemed to be restorable. There's usually a stipulation between the prosecutor and the defense counsel to stipulate that they're not fit to proceed and that they should move into restoration proceedings. That's typically the way it occurs. So again, I don't even know that the only time there's a finding per se that the court has to make is when there's a contested hearing on competency where you may have dueling experts, and then your finding would be based upon the testimony and provided, which is in front of the court. So again, I guess I'm struggling to see where that's a problem, but I'm not on the bench either. So that's good feedback that we can take back to consider.
Before we get to more confidentiality, I see Judge Steele just has a question, reaching out to the other centers, I'm assuming the regional centers, to assure availability and coordinate time of the evaluations. Is this something the parties would do?
Yes, parties should do
And I don't
that.
know if Dr. Etherington would like to weigh in on that.
So ask me a specific question, Aaron.
I guess the question is just the coordination of the evaluations. The parties certainly can do that, but is that in consultation with the regional human service centers or the state hospital? Or how do you envision that coordination to go?
I would think it should stay central through the state hospital, and we have been coordinating with the human service centers, right? So they are informed. But so for the evaluation purpose, it will always be an evaluator that is assigned to the state hospital because of the specialization. It's just that it could be done on an outpatient basis, and then we coordinate that, through their means.
So I don't have the whole section in front of me, but doesn't the statute say we have to order them to the state hospital, or does it say at least for the initial examination? Or does it say the least restrictive in there?
It says the least, sorry, go ahead, Travis.
No, it does say least restrictive appropriate setting now. I believe there was some reference in the past to the examination being conducted at the state hospital.
So one of the problems I found, even with like off the street mental health petitions, is you're supposed to order that they be examined somewhere, but you have no idea, like you can't just put in a name in a facility and say, okay, go there. You have to have an appointment. You have to know where they can go and who can accept them. And if the parties aren't coordinating that, it's really hard for the court to get involved in that. And so are the parties being trained and informed? Like, are the defense attorneys being informed about these options, and who do they each have a contact person at each of these facilities in the various regions that they know they can contact to set these appointments up?
Yes.
Okay.
And that is, Travis, correct me if I'm wrong, but that is why we kept it really central to the state hospital. So they have the contact information to the state hospital employees, and then they in turn coordinate with the other facilities.
Correct. And then typically if there's going to be an evaluation done by a private provider, that's usually not done through the courts anyways. That's usually done through the processes available to practitioners, at least in indigent defense cases, through the Indigent Defense Commission. So that's done a little bit differently. And so the last thing I would say, kind of tying it back to the slide here, the last thing I would say about that confidentiality section, and the reason why I don't think it's as big of an issue, that was actually a recommendation from the National Center on State Courts based on best practices. So that wasn't a 3-4 people sitting in a room type thing. That was a recommendation that came from the National Center on State Courts and their technical advisement through the grant that we had received. So again, I don't know how other states are doing it, but that was the recommendation we had received from the National Center on State Courts. Other things that didn't change in the temporary detention, still the temporary detention cannot exceed 30 days. So if there is a necessity to have a detention be longer, typically what occurs right now is they're transported down there the day of the evaluation and they're transported back after the evaluation that day. There are processes in place within the statute that can allow for that detention to be longer if necessary for the purposes of completing the examination. Next part talks about the necessity that the evaluation be completed by a Tier 1A mental health professional. And that was in the old law, but maybe Dr. Ellington, do you want to provide what Tier 1A would be?
Absolutely. So tier 1A, which really originated in the commitment statute, has to do with that set of professionals that are with advanced degrees such as psychiatrists and psychologists.
And then part 2 on the examination here is really where the definitive timelines that we indicated came in, which is really an important step too, so we don't have people who are in a state of decomposition or in a state of mental crisis sitting longer. Typically, what we found is if these people are in custody, we obviously don't want them in custody longer than need be if there is possibility to get them restored. So what the statute came up with was the examination must occur within 15 days of the entry of the order being served upon the Tier 1A mental health professionals. So what we added into statute to ensure that we could comply with those 15-day deadlines is that the attorneys would disclose any necessary materials, such as discovery materials, things like that, contemporaneously with the order. I know that's one thing we've been working on. So I think that is one thing that Dr. Etherington was requesting that would be included in the orders. But am I speaking out of turn there, Doc?
No, you are not.
And then if the evaluator is not able to complete the evaluation within that 15 days, there can be an additional 7 days if there's good cause shown. And obviously that would be an extension granted by the court.
And I'm sorry, Travis, could we take opportunity for a minute to identify that, why it is important for us to have all those necessary documents to complete that evaluation?
Please
So
do.
I'm sorry, go ahead.
No, please do. Please explain.
So because we really need to look at, we're not just doing a mental status of the individual to determine what is their current state of mind. We really have to judge that against, the understanding of the charges against them, which then means we need all those documents. And then that capacity to know, based on those charges, what's going to happen in court, what are the potential outcomes. And it is difficult in getting these materials is difficult already because they don't just come to us, they really should. And then getting all of the documents is sometimes difficult and we have to be calling and asking. And so one, I would argue that we cannot complete the evaluations without that complete set of documents.
So that's why we did put in the statute, and we have now also, as I had indicated previously, we have spoken with the defense attorneys and then also at the state's attorneys conference, making sure that those materials be provided. Sometimes if this is at the very beginning of a case, defense counsel may not yet have those discovery materials. So the state may be able to just send what they have. And obviously it may not be all of the materials, but hopefully it's enough. The next part is that once they make that examination, they then have 30 days to write the report and provide that to the court. So again, keeping those timeframes moving and making sure that we're not having someone who's in the state of crisis sitting in crisis for long periods of time.
And we are on, so there is only one case whereby we missed the 15-day deadline. And we needed to inform the court. Otherwise, we are trying to complete those reports in a sooner time frame than the 30 days. Knowing exactly what Travis indicated, that we don't want somebody to sit in languish, particularly for those that we are of the opinion that do not have fitness and need treatment.
So what we have is we also put and really carried over from the former statute the requirements of what must be in the report. So it must include the identity, the individuals interviewed, and records and other information considered, the procedures, tests, and techniques, the date and time of the evaluation, et cetera, et cetera. So again, you'll get a copy of this, and it kind of, as I said, attempts to walk through the statute. The one thing I did want to make sure we highlighted is the opinions are supposed to also have a determination by the evaluator as to whether or not the individual, in their professional opinion, will attain fitness to proceed within the timeframe set forth in section 08. And we'll go through that here in a bit. But it's really important that if nothing else, that should be in the orders that's being prepared for you, because defense counsel and prosecutors have been informed of this. But if it's not, I think the evaluators know about it, but it should also be in the orders that's coming from the court to make sure we're in compliance with the statute. And then also, if they're unable to determine whether or not they're to attain fitness, they're supposed to state in the report why they feel they're unable to make that determination. Next thing is again, talking about the hearing, and they both have the right to cross-examine the persons responsible for the report, etc. Again, this is the suspension of the proceedings, and really there's two options, and we broke up the statute a little bit here to try and make it easier to understand. There's two options in these, well, really three options. First one would be if someone is determined to be not competent, not restorable. There's not a whole lot more the court can do. Those proceedings are dismissed. They can be referred for other proceedings such as guardianships, things like that. Option number one that we go through in here would be if a person lacks fitness, but they're found that they are able to be restored. So in 12.1040801, it really walks through the restoration process. Again, there was some indication about suspending proceedings in the former statute, but there was no definitive method of restoration. So again, if someone is found to lack fitness and it's indicated that they will be able to regain fitness upon a course of therapeutically appropriate treatment, the proceedings are suspended. For a defendant charged with a felony, they're suspended for a period of up to 180 days. The court may extend that suspension for an additional 365 days if there's medical evidence to believe the defendant would attain fitness in that additional 365 days. For a defendant charged with a misdemeanor, the proceedings are suspended for the longest period of time available on the most serious misdemeanor. So for a Class B misdemeanor, it would be 30 days. For a Class A misdemeanor, it'd be 360 days. Realizing that seems, this is again one of those things that was changed through the course of the legislative proceedings. With the felony, and Doc, maybe you can speak as to what we know as far as best practices, but most people are typically restorable within that 60 to 90 days.
Yes, absolutely. Somewhere between about a 45 to 75 days, really. And the outliers then become the 75 to 90. And there is a question in the chat.
I asked if I could just interrupt and ask a question of relating to this. In some of the proceedings where they're found that they're not going to attain fitness, it seems as though it's really not appropriate just to say you can make a referral, but if there's not already a referral in place, you're taking a person who needs help and kind of throwing them out on the street. If you just say, okay, dismissed, I'm going to refer you to a potential guardianship. If those proceedings haven't already started, it really puts the court in a bad position. And so is there somebody who is responsible for coordinating this? Is the state hospital reaching out? Are the attorneys supposed to be reaching out? Who is supposed to be, or maybe nobody is, coordinating that in the meantime so that there's something in place? So this person really needs a guardianship, but they're probably pro se, or they don't, or they're having indigent defense counsel help them. Whose role is it to get that started and have that in place so that that person isn't just kind of kicked to the street without any supports?
So I'm going to separate for a minute the issue of conservatorship and guardianship with treatment. So the state hospital will absolutely coordinate treatment, and we will not kick somebody to the street. So in general, most of the time, the person is being treated at the state hospital because we have found that their illness is so severe they need hospitalization. There have been a few cases where we are treating them outpatient through coordination with the Human Service Center. But generally, they are here at the hospital. We've been treating them. We treat them to court competency. We are assessing ongoing to make sure, do they continue to meet criteria for hospitalization? And if they do, then we would recommend to the court, hey, look, they're not gonna attain fitness, but we need to keep them at the hospital and continue to treat. And then we, of course, would coordinate then the discharge to the outpatient provider. In the event we don't think they still require hospitalization, right? Then we would also still coordinate with the Human Service Center. And even if that person goes back to jail for a period of time, We send that referral to the Human Service Center, we do a team meeting, and then we ask them to continue that care even in the jail. And particularly those medications, which are the most important piece of that treatment, to make sure that they, to make sure that they stay stable, right? And that they not end up in such states of psychosis, more often than not, in states of psychosis. What that means, however, in regards to those that are that have such severe illness that may require conservatorship or guardianship, that becomes a little more complicated. But although we do coordinate that through the Human Service Centers, we also do a large number of guardianship proceedings here at the state hospital, right? We seek guardianship for many of our clients that are here. I'm actually going to write a note to myself and really look at how we could do that better to determine.
I have had situations where that has happened, and it was concerning because as the court, you feel this person can't just be released, but the losses you have to, and there wasn't a petition filed in the mental health court. There wasn't a pending guardianship petition filed. And so if nobody's really in charge of that or doing that, I just wanted it to be on the radar, and I just was wondering how it worked. It sounds like there are things in place, but I don't know if they're always occurring.
So as far as the coordination for the purpose of ongoing care, yes, that is always occurring 100% of the time. As far as consideration of does this person meet criteria for guardianship, I can't say 100% of the time. We are really looking at that issue when we're so concentrated on the acute nature of the psychosis and reattaining fitness, right? So, but we can add that to our process of assessment because we are so frequently looking for issues of need for guardianship. I think and this is maybe for something for Aaron and Travis and I to discuss. There is a hole in our commitment statute that does not allow us to pursue an alternative treatment order at an outpatient basis. It requires a person to be in a hospital and for you to convert a commitment from hospital to outpatient. I would love for us to be able to actually pursue an ATO in an outpatient world for a person who never even has to come to a hospital. And I say that because I think in context to this, we could then seek ATO for people that have been in the hospital setting, but not under commitment. So we couldn't actually convert an order, but then at that completion of treatment, go to jail, drop the charges, we could seek ATO so that treatment in the Human Service Center has more court oversight for continuation.
I think there was one other.
Travis, Judge Bailey has a question on the timing in terms of what if the jail hasn't transported the individual or what if the hospital hasn't taken them? I don't know if Judge Bailey, you would like to kind of expand on that a little?
I'm sorry, I do not mean to dominate the conversation. Obviously, it's an area I'm participating today because it's an area of need for guidance. But the timelines in the statute are nice, and I'm wondering if anybody has ever done any study on the reality on the ground. And I'm just wondering what really happens on the ground. And I can only present anecdotal concerns. I've held hearings more than 60 days after entering an order, and commitment or detention really isn't an issue because the person's already in jail being held on bail and they haven't made bail. And I'll have a hearing 60 days down the road thinking, oh, that's plenty of time for all of this to happen. Get to the courtroom. There's been no report filed. And then I'll find out in some cases, defendant was never transported. For the evaluation, jail staff might say, well, the hospital wouldn't accept the transport, Or I might get a letter from Southeast saying, well, the defendant, if they weren't in jail, if they were out on bail, they didn't show up for an appointment, or the defendant was visited at the jail but wouldn't cooperate, so they didn't do a report. Whereas if they had gone to the state hospital, even if they hadn't participated, they could have been observed, and a report should have still been created and filed. And I'm sorry to say, but this is not an isolated incident, but I've had occasion where I've ordered made an order for a report and a report not filed, and the whole time the guy was at the hospital. And no one asked for an extension of time to file the report. We just didn't get a report. Then we're scrambling, trying to find out, where's the report? Where's the guy? Why isn't he here for his hearing? There seems to be a real disconnect between what I'm experiencing and what the statute lays out and what I'm hearing. And so what really happens? I enter an order. I don't really have any power to do anything else besides enter an order. What happens on the ground? Who's responsible for following through?
Yeah, and Judge Bailey, I can take a stab at some of that. Some of it should be defense counsel. Obviously, if it's their client, we always encourage people to make sure they're staying on top of it. Also, I've been privileged to be serving with the National Center on State Courts Judicial Task Force on examining state courts' response to mental health. And one of the big things that continues to be pushed is the best practice of having the court be more involved in overseeing this process of making sure that these evaluations take place. So whether that's scheduling a hearing at a definitive period of time to see where it's at, having an order to show cause, whatever it would be, asking the parties to report to the court as to the progress. As to some of the other concerns with.
And who should be named in such an order to show cause? Dr. Etherington? I don't think she would appreciate that.
Well, I think the parties. The parties as to what's going on and where are things at. In your example of the individual not being transported to the state hospital, it would be interesting to know why the sheriff didn't transport if there was a lawful order from the court ordering them to transport.
They're told, don't bring them. There's no bed.
And maybe Dr. Etherington can speak to that, but I'm not familiar with that. So,
Well, and I would need to have a case to actually follow up to see if that was ever said, right? And I would hope that it was never said. So we keep a log ourselves of the orders. And so part of why we worked with the court to get those orders directly is there were times when we never received the orders. And then we'd only learn, 30, 60, 90 days later that we were supposed to do an eval, and we didn't even know it because we didn't get the order. But now we get every order. And the sheriff's departments are, in my opinion, relatively efficient in making the call to say, okay, now we have a transport order, when can we bring them? And so we coordinate that time. And I know there is a matter of days when individuals have had to wait, but I don't have anything on my record that said we have never received anybody or refused. So I think important, if those cases occur, we absolutely need to, if we don't answer to the court, we absolutely need to go backwards and say what broke. But I think what complicates
I'll reach
this,
out to you privately.
Absolutely.
I'm going to be quiet for the rest
Okay.
of this lesson here today.
by all means, you do not have to keep quiet.
Was there anything else you wanted to provide on that, Dr. Etherington?
Well, I was going to identify the fact that because we are, one, we need to know the order exists, and two, we need the discovery material so we can actually schedule that assessment. And three, then we are reliant on scheduling that and making some determination if the client will cooperate in the jail setting or we need to bring them on site. I do know that we've had cases where we have actually tried to do a telehealth in the jail. They have refused to cooperate. And so in those cases, we've written a letter to the court to say, hey, they wouldn't cooperate. Now we're asking for them to actually come here on site and then to remain for up to 30 days so we can do the very thing that Judge Bailey had requested, which is then we do the observation, we really try to engage them, we try to get them to comply. There have been one case in the last 6 months that even in that effort refused to comply, right? And so then we needed to write another letter to the court to say, our apologies, but we have made all of these attempts and they still, won't cooperate. But otherwise, we have generally been able to accomplish that, get the report done and file with the court.
And I think it's important to understand procedure on defense counsel side too, and I can't speak to the prosecutor side, but on defense counsel side, we train our employees that when they receive or ask for these evaluations and receive an order back, that they communicate with the scheduler at the state hospital. And when they communicate with the state hospital, they send what discovery materials they have once the order is entered, and then find out that day when they are available for that evaluation, and then prepare a transport order accordingly. So that's what should be occurring based upon our policies and procedures. So also, if that's not occurring too, certainly feel free to let me know and we can try and take remedial actions as to the defense counsel side. And I will go back to the PowerPoint here. Bear with me. This one. The next, continuing on option one, if the court determines the defendant lacks the fitness to proceed, but they may attain the fitness, they may enter an order for course of treatment concerning the least restrictive appropriate treatment. Again, one of the things that wasn't clear before is whether or not the right to counsel extended, where that right to counsel was at. So we made it clear in the statute that trial counsel would remain on that. So if we've also made sure in our policies and procedures that if trial counsel represented them at, if it was indigent defense at the trial level, then it would continue to be indigent defense for purposes of hearing during the restoration process. Also, in a motion to resume the prosecution, the state or the prosecuting authority must show by a preponderance of the evidence the defendant has attained fitness to proceed. There's quite a bit of discussion as to what that standard should be, or whether or not there should even be an evidentiary standard included in the statute. But as it worked its way through the legislative process, that was the result. If the court does order a defendant committed to a treatment facility, so it examined the least restrictive appropriate for or therapeutically appropriate treatment facilities and determined that they do need to be committed to a treatment facility, then there's a provision that the court shall provide special custody and commitment terms in the order. And basically making sure all of those, kind of laying out the guidelines, if you will, similar to a civil commitment as to what is appropriate. And then the special terms of commitment must include, in order for the defendant to accept all non-experimental, generally accepted medical, psychiatric, or psychological treatment recommendations. Because we did order or did include in the statute that that would be requirement, that they accept that. We did allow for that counsel to remain on. So if the defendant did not agree with it, counsel could bring that appropriately in front of the court by appropriate means. We did put in there just as kind of a fail-safe, similar to the way it is in the criminal responsibility restoration chapter under 12.104.1, that if the order does not indicate the terms of commitment, that the director or the superintendent may determine the nature of the constraints necessary. And then also that at least 60 days before the date specified for review, so those timeframes, that the superintendent or the designee of the treatment facility would file that report with the court. Again, this is the modification that allows for those modifications to come forward. So any party to the action can bring a request to modify those special terms of commitment. And then also carrying over from the old law that just because they're in the process of competency restoration does not mean that they can take or not take appeal or any other sort of action. So they still have those authorities that carried over from the old law. The second option really is if, and this has kind of got to some of the questions earlier that I think Judge Steele had, that if an individual lacks fitness, but they're also found that they're not restorable, those proceedings are dismissed. So you have the proceedings must be dismissed. And then the court may at any time make a referral for other appropriate services, whether that would be appointment of a guardian and conservator or a civil commitment of the person pursuant to Chapter 2503.1. I will tell you that the same group that looked at the competency law also has on its wish list to take a look at criminal responsibility and also the civil commitment law under 2503.1. I know also the interim judiciary committee in the past few interims has been looking at the civil commitment statute under 2503.1. So there's a lot of work to be done. And that's why I appreciate the feedback we've had here regarding some of the confidentiality concerns and everything else. So some of the challenges that we've seen, obviously to this point, and is making sure those materials that are necessary to conduct the evaluation are getting to the state hospital. The length of time between an identification of when someone is determined not to be fit and the order for hospitalization. So if someone is found not to be fit, so typically the way the process works is if someone is evaluated, they're sent back to, say, county jail. And then once that report is issued, if there's a long period of time before they get into hospitalization, that can really decrease the opportunity for a quicker restoration. So it's important to kind of make sure we're staying on top of those things. And also that's best practices of the courts. And
Hey,
then
Travis,
also,
let me just stop you there. Judge Hager has a really important question, which is in regard to who files the guardianship or commitment petition. Well, obviously the state's attorney is your typical civil commitment, but the guardianship, I think, is something we need to do better on and to create a better process for that. As we just talked, Rosalie, Dr. Etherington has some availability of filing those. I think that's probably the easiest, but we've got the guardianship thing's a mess, Judge, you know that.
yeah, and Doc, did you want to say anything more about the guardianship aspect of it?
Not at the moment.
Okay. And then the other challenge and concern that we just wanted to talk about is the length of time between the restoration and the trial. So it really wasn't brought to my attention until we started looking at these type of things and my involvement in the national task force, that the state hospital may be able to restore someone and they're restored, and if they're on a pretrial detention status and they're sent back to the county jail, depending on the formulary that the county jail has, there may not be an ability to continue the same medication. And I was happy to hear that the state hospital tries to work with the different county jails as to their formularies to make sure we don't have decomposition issues. So the concern is especially with fitness, you get someone evaluated, they're determined they lack fitness, and then we get a report that says they've been restored. If that same level of treatment or medication is not continued when they get sent back to the jail, there could actually be a period of time in which they decompose back to a state of lacking fitness to proceed. So really there's that concern there with the timeframes and making sure those are pushed along. But that's really what we had as far as a slide deck. Did anyone else have any questions, comments, or concerns that I can take back to the group? And obviously we'll have to take back the confidentiality concerns with the hearing on that, and then some of the guardianship stuff that was brought up as well. But does anyone else have any concerns or comments about how it's been working in the courts?
Travis, I had one thing I wanted to bring up, and I think for a couple of the judges here in South Central, one issue we've had is getting reports back on time. Who should we be looking to, or who should we be prodding to get those reports back to us? It's been, 60 days sometimes before we have reports back.
So are you talking reports for the issues of restoration of competency, like
Yes.
fitness to proceed?
Yes.
So So I think we'd have to actually evaluate that a little further. So of course, it's our job, once we actually start the clock. But I think some of the problem is we are not getting discovery materials, and we are not starting the clock of our requirement of 15 days until at which point we have the material to do the evaluation. So I can say without fail, right? We have the materials, we assess the person, we get that report to the court on time. So that 60 to 90 days, if it took that long, that means we didn't have the material until just 2 weeks before you get the report. So I guess I'm struggling with, you can surely contact us and we can inform you about what we're waiting for. I have, and so my administrative staff, we're trying to actually probably what I would call over report to the court when we were waiting for materials. And I suggested to them that they needed to stop doing that, because frankly, they were spending hours and hours per week doing that and actually not getting all the other work done as far as making sure our evaluators had their materials. So I guess I'm not sure I have an answer for you, but we will be completing the reports within the timeframes identified in the law, but we will start the clock when we get the material.
That's helpful. That provides some information or understanding of the process of where we should be looking to make sure that's happening. So thank you.
And Judge Nusma, one of the things we've been dealing with both defense counsel and prosecution counsel is sometimes just getting those reports. As practitioners in the field, we may not have, state attorneys may have some documents, but maybe not everything that, the state hospital is looking for. And, it's possible if defense counsel is just appointed and, makes this order right away upon their first meeting with the client, that defense counsel may not have hardly any discovery materials yet beyond the, initial disclosures of the complaint, maybe the citation or the white page with the citation. So really, sometimes we're just put in that position where the information may not even be over from law enforcement yet, over to the prosecutors, which then, take that time to disseminate to defense. So we did have that conversation with, again, both prosecutors and the defense, that it's not just defense's responsibility, it's all of the attorneys involved responsibility to get those materials to the evaluator. So hopefully that will pick up as people become more and more knowledgeable on what the law actually requires.
Thank you.
Anyone have any other thoughts they want us to take back to the group working on this?
Travis, although not part of the real decisions today and the presentation today, the competency, as Dr. Etherington mentioned, with a huge increase, in particular, competency issues regarding very minor misdemeanors continue to rise. And it doesn't seem, and that this is not a problem with the current law, it just doesn't seem like that's an effective use of state hospital resources. And I know that's not what we're talking about today, but that is on the agenda for the state's attorneys to see if there is a better way to deal with cases like that.
And Aaron, if we could, would this be the time where we could talk briefly about the pilot that we're about to start in the Bismarck region?
Well, because I haven't heard back from Judge Phelan yet, probably not.
Okay, I can tell you with absolute certainty that she is on board. So I'm surprised that she hasn't reached out yet, but she's waiting for the meeting. So maybe I'll give her a call.
So just to briefly fill everybody in, we would like to try some sort of pilot with small time non-public safety misdemeanors when they are sent for competency issues, to see if there's a better way the prosecutor and defense attorney could resolve the case without having to go through a competency issue. And I know that's the high level version, but we are looking at that very complicated issue.
Yeah, I don't think it's any secret that mental health continues to be one of the major factors driving the case numbers that you all are seeing as district court judges, especially in the criminal arena. So that's why the National Task Force are looking at, mapping out different potential off ramps and things like that. So it's exciting to see that we're working on, and the Supreme Court committee that's also looking on this is also looking at some different, potentials that might be out there for state, county, community partnership type things to provide some of these off ramps to work on some of these competency issues. And so we're getting people the help that they need rather than, basically, unfortunately, having to keep some of these people in custody or in the state hospital to protect themselves and others.
Yeah, and I know we're up on time, my only final thought from the prosecutor's standpoint is there's no reason that we need to fight on procedure. There's going to be obviously times that we disagree, but we at least needed to update the statute, and the Supreme Court was identifying what could have been some fatal flaws in the current legislation, and not to mention the person shouldn't be indefinitely be in the fitness to proceed chapter. So I think this was our first stab. I don't think anybody believed this was going to be a perfect bill, and so that's why we're doing these presentations. So if you have other ideas or things that in the practical world are not transferring into the law, certainly would love to hear about it. That's all I have. Thank you for the honor of being in front of you all.